When an insurance company tells you not to worry, worry. Today's guest has built a career exposing every game they play once you sue. From the lowball threat to the independent doctor who is anything but. Sagi Shaked is a board-certified Miami trial lawyer who's won millions for families in their worst moments. We get into wrongful death, traumatic brain injuries, and why the lawyer who does only this work is the one you want in the room representing you. This is Legal Latitudes, and I'm your host, Federico Lathrop. Sagi Shaked, welcome to Legal Latitudes. It's a pleasure to have you here.
Yeah, thanks for having me. Look forward to our conversation today.
So Sagi, I've heard a lot about you. You're in Florida, right?
Correct.
And became a trial lawyer at a young age. What made you become a lawyer in the first place?
So I've always wanted to help people, and then it was really my dad who had this vision for me to be a lawyer. He said I'd always walk around with a briefcase. I don't know, that doesn't have anything to do with the law, but it's kind of what I wanted to do as a young kid. And then going to law school, you start seeing how the cases play out, and it got really interesting for me. So really it was from a young kid I wanted to be a lawyer. Now, of course, don't get me wrong, I wanted to be a basketball player. Okay. My goal was to be in the NBA. I was never good enough.
Well, you're tall. How tall are you?
Yeah, 6'3". You're tall too, right? You're 6'4"?
Yeah.
Yeah, so I wanted to play basketball for a living. That didn't happen, so I settled on the next best.
Are you a good basketball player?
I'm okay.
Okay.
Not to the level you need to be, that's for sure.
Okay. Well, I mean, it's good to have these, hobbies and things that make you feel like good with yourself. It looks like you work out and keep that active life, right?
Yeah, absolutely. I'm always at least 5 days a week. I'm in the gym, taking care of my health and that kind of stuff. I like it.
That's good because trial lawyering can be very intense on the body, so you need to keep the score, right?
For sure, it's stressful beyond belief. You know, clients are calling you, then you got the defense lawyers always trying to beat you down, adjusters trying to beat you down, and so it's the one time like when I'm working out, I'm in the zone, I'm not thinking about work, so I get to focus on whether I'm with a trainer or working out with my brother. We just focus on working out, so I don't have to think about work.
Now, you said your dad inspired you in a way. Yeah. You said with a briefcase. Yeah. Is he a lawyer as well?
No, he's not a lawyer.
Okay.
My dad's, he worked as a mechanic his whole life on cars in the garage, and he's like, the last thing I want you to do is work with your hands. So he's like, you're not going to work with your hands, you're going to work with your mind. So that's kind of what ended up.
So for you growing up, you're seeing this inspiration of this is what being a lawyer is. Did you want to be a trial lawyer from a young age, or did that something that happened all of a sudden? What's the situation there?
So definitely a trial lawyer. I didn't want to work on contracts. Not that there's anything wrong with that. We need those types of lawyers too. But I wanted to be in the courtroom. That's where I saw myself, being a courtroom lawyer. And not a transactional lawyer. Even in law school, I took the courtroom path, not the transactional path. I like being in front of people. I like talking in front of people. And when you're younger, it's nerve-wracking, right? And still sometimes you get in front of a lot of people and you get the nerves a little bit, but the more you do it, it's like repetition. The more you do something, you just get better and better and better at it. So anyone who wants to become a trial lawyer, you just gotta get as many opportunities as you can to speak to people.
Right. So you speak in several conferences, right, and present in front of other lawyers. What are the usual topics that you present on?
So most of the time when they ask me to speak, and I speak across the country, probably once a month, sometimes twice a month, on traumatic brain injuries, is where I found a niche, because initially what I would start is I would do orthopedic injuries. I was a young lawyer. Everyone's doing orthopedic injuries. I thought that's the way you do it, right? Let's get the spinal case. And then I had a couple of traumatic brain injury cases, started to learn everything, and then got fascinated with the brain and found that I can really help people. So that's kind of where my path went. Some people, go into cases against trains or aquatic cases or negligent security cases. Mine went to traumatic brain injuries.
Okay, and what is it from the traumatic brain injury cases that attracts you and makes you feel good about them, on handling them, and being so complex, right?
Yeah, it's the brain. That the brain is so fascinating. So we have our conscious brain and our subconscious brain, right? You have the brain that we know we can get to, and the unconscious brain. So just it fascinates me to learn how. Like there's I don't know if you read the book Persuasion by Robert Cialdini. Yeah. So there's great things in there. I like reading. I like learning and getting better. So I'm always trying to get better, and the brain just fascinates me. So that's kind of like, if I can help someone who has an injury that's invisible, right? Because they look normal. They look like you and I.
Right.
And so that's a problem, because juries, there's a study done with the Brain Injury Association of America. It's called the Harris Poll. Mm-hmm. And the Harris Poll says that 80% of the people believe that they can tell if someone has a brain injury just by looking at them. Wow. And you and I know that's not true. Not mm-hmm. And the problem is, think about that. If people believe that your client, just by looking at him, is normal, that's a problem. Right. So when you're picking a jury, you have to think about those kind of things. Mm-hmm. So everything related to the brain just fascinates me.
Right. And I would like to talk later about the things that you do to prepare for these cases and how you present them to a jury so that you can convey the human story in a way that they believe your case it's worth something, right? Sure. And then also a lot of lawyers, based on what you just said, miss these brain injury cases, right? They have them. They have a bunch of orthopedic cases, like the way that young lawyers start, but then they don't realize that their client is suffering with a much deeper and detrimental condition, which is this traumatic brain injury that is affecting their soul. I like to say that, right? Like it changes your life. Is it your experience that sometimes lawyers call you to help them with one type of case, and then you realize we're missing this bigger case here? Has that ever happened?
Yeah, that happens a lot, because again, just like I started off, maybe the first 7-8 years, I thought orthopedic cases, and I probably, going back, I mean, statute of limitations is now passed, I probably missed out on a lot of these traumatic brain injury cases back in the day. But now I recognize them more, so what I like to do is teach on them. One of the things I think that's important, when you have a traumatic brain injury case, you really have to think about it and treat it as a wrongful death case. Okay. Someone on that day died. Yes, they're physically alive, but the way the family members usually describe it is this is a completely different human being that you're seeing right now. Right. They might look the same, but operationally in their head, that CPU just doesn't work the same. So I always tell people when I'm teaching these classes, that's how you treat these cases. It's a wrongful death case. Treat it like that, and you're going to get good results. It's the right thing to do for your client, right? Because they have a real injury that they sometimes don't even recognize it. Because you can start acting differently, and you don't know it until someone tells you that you're acting a little differently. So that's kind of what I want to teach. And then we go through the significance. First, we talk about what is a traumatic brain injury, and then what is the significance of it, how often it happens. And then I teach them some definitions, and then we go through, yesterday we did, we're in 2026 now, right? So yesterday we did an 8-hour class just on from A to Z, from signing up the case all the way to, picking a jury and doing direct and cross-examination at trial. So it's hard to do in a small fast podcast, but just to give you an idea, I think the major thing you can take out of that is what I said earlier. It's a wrongful death case. That person on that day is no longer there, and a new person, and then you use before and after witnesses. Okay. The family members, the friends, the coworkers who can describe what they were like before and what they're like after.
Right. What's challenging about these cases is that your client usually likes to be better, likes to be they pretend or act like they are not as injured because they want to show they are resilient. So at times you see these TBI clients and they say, "Oh no, I'm fine. I haven't suffered any injury. I have a headache here and there. I'm not sleeping well." But that's like they try to link it to something else, because TBI cases have such an stigma, right? Like if you hit your head, you're not gonna work anymore the same way you used to work, or be a good student, or and a chain of different situations. So what you're saying of using before and after witnesses, that's key. In terms of experts, I know that there are different lines, different school of thought. Some people like to use neuropsychologists. Other people don't like to use neuropsychologists, and they instead like to undermine the other side's neuropsychologist,
Right.
using a neuropsychologist as a consultant, but not designating them as expert. What's your preferred approach, or is it like a case to case?
So it really is a case-by-case approach. So first of all, I like the neurologist to quarterback the case, right? So the neurologist is going to be the doctor who's going to quarterback everything. And then, so remember, the neuropsychologist is testing for the functional aspects of the brain,
Right.
not anything else. So the neurologist will tell us what happened, how the brain got injured, and then also talk about function. And the neuropsychologist, so I'm not a fan. I do work with neuropsychs. It's a case-by-case basis.
Okay.
Sometimes you need it, but the defense in every case is going to find a neuropsychologist who's going to say the exact opposite of what the treating neuropsychologist is going to say. I've been doing this now, and we're in 2026, so 26 years. And I've never had one time, and even in some of the severe cases, where a defense neuropsychologist says that the person's injured from the crash, that they have functional limitations from the incident. They always say something that's favorable to the defense. And it's what a lot of people like to call it junk science.
Right.
So if I can prefer without it, I prefer without it. But if we
okay.
have to deal with it, I've done it and dealt with it as well.
Okay, so you would put on the stand your own neuropsychology sometimes, and
Ideally, I would prefer just the neurologist quarterback it, but
Yeah.
we have put on the neuropsychologist. You can also keep your neuropsychologist for rebuttal.
Right.
So this way, they don't have anyone to rebut your neuropsychologist, because your person's going to say X, they're going to say Y. That's kind of, write each other off. And I think what makes the game or changes the game is the before and after witnesses.
Right.
Because, yeah, these are both paid doctors, I get it. But the coworker, they're not paid.
Right.
Family member, yeah, they have an interest, right? But the clergy person from the clergy, a local neighbor, they're not getting paid on that case. So they can neutralize a bad neuropsychologist for the defense.
Okay. Now, I had a situation with a potential client where she called me and said, "Hey, I was rear-ended, suffered a whiplash injury. I hit the back of the headrest, and since then I've been feeling these headaches and I'm not sleeping very well. I went to see my primary care physician and they gave me some meds. And I told her, well, you need to see a neurologist, and perhaps in a little bit, you're gonna have to get an MRI that will or not show something." And she said, "Well, I asked my doctor, and my doctor said that an MRI is not gonna show anything," without even, looking at the MRI. I told her that doesn't matter, right? Because TBI cases are clinical, and I would like to get into that, because many people think that because the imaging is not going to show any type of bleeding or any type of injury, they don't have a brain injury. And I know that that's not the case, right? In your experience handling these cases for 26 years, you've seen that multiple times, right? A very, very big cases that are clinical that don't show in an MRI. What does it mean when you're saying these cases are clinical and sometimes you don't get the MRI as a support? And how do you deal with that?
So that's a great point. So I'll tell you, in January of 2026, about 5 months ago or 6 months ago now, I was in trial where the CAT scan was negative and the MRI was negative. And the defense, starting in jury selection and in opening, what were they doing? Exactly what you were saying. You're going to hear about a CAT scan, and a CAT scan is where they examine the structural integrity of the brain, and it came back negative. And then you're going to hear an MRI, and the MRI came back negative. And so their whole approach was the GCS score, which is the Glasgow Coma score, was 15. And the negative DTI and a negative negative MRI and a negative CAT scan.
Right.
So what do? That doesn't mean the person is not, their brain is not injured, just because it's one picture at a moment in time. So, and the literature, not just me saying it, there's a lot of literature. And what I'll do is maybe when this podcast is over, I'll send you the literature so you can put it as a link for anyone who wants to know. A negative CAT scan does not mean you don't have a brain injury. It just means that they don't need to operate on your brain at that moment.
Right.
And then what the PCP said could be partially true, right? And a regular MRI will come back potentially with nothing. That's why you need to do an MRI with a sequence called diffuse tensor imaging. And what that's looking for is what they call FA values, and they're looking at the white matter tracks. Right. So you have white matter and gray matter, but what we're looking for is the white matter, and then we're looking for what they call axons and neurons. The axons connect to the neurons. So you got to think about it like a city. And if you're trying to get to where you want to go, and I'm blocking off all the roadways, or all the roadways basically had a earthquake, and they're all broken, and you can't get to where you want to get to. So if it's like, where do you live, in California?
Yeah, in San Diego, Encinitas.
Okay. Okay. And so to get to the San Diego, it's the 5, I think?
Right.
And there's another highway I can get to San Diego, right?
Yeah, the 15, the 5, and yeah, I think it switches, but the 101, yeah.
So imagine if I do that, and the axons, let's say you have a frontal lobe injury. The front part of the brain deals with emotions, processing. So if the front part of the brain was injured, we'll work it like going from right here, we're in Huntington Beach, going down to San Diego. If I take away the 5, the 15, and some of the other major highways, you can still get to San Diego.
Right.
But it might take you a lot longer, because it's sort of like I'm doing this, but I have to do this, right? To my ear. You can still get there. It's just going to take a lot longer to get there. Your processing is a little slower. Right. That's what that DTI would show.
Sorry for interrupting you, but for people who are listening and not looking at the video, what Sagi just did was he touched his ear with his right hand, and then went behind his head and touched his right ear with his left hand.
Right, yeah, so just to demonstrative, to show that you could still do it, it's just going to take you a lot longer. And so that's when people really get frustrated. They're used to be able to get the words out right away, and now they can't because that processing delay is taking a lot longer. So the axons were stretched or torn, and this is good if you can show a demonstrative exhibit at, like right now we would show the demonstrative exhibit if I'm teaching a jury or teaching class to show what we're talking about. So a regular MRI, so for the viewers, it's okay. If the CAT scan is normal, that's what the definition of a mild traumatic brain injury is. You're most likely going to have a CAT scan that's normal, because if it wasn't normal, you'd be having a moderate or severe type of brain injury. Right. So CAT scan's always going to be normal, and then your MRI could be normal too. Because in the case we tried in January, they offered us $50,000. We got $4.5 million with a regular Glasgow Coma score, and I can talk about what that is, negative CT and a negative MRI. Right. So it's not the end of the world. Don't think, as long as your client makes a nice appearance and they're a nice person, the jury's going to want to help them. Right. It's when I think the clients, I give this example. If you think they're not credible, or they lose credibility, because if it walks like a duck, quacks like a duck, wiggles its little tail like a duck, it's probably a duck, so you're not going to believe them. So if you lose credibility, I think you lose the case. But if you still have credibility and you can put the other tests together, the QEEG, the VNG, the balancing test, and all the other tests that you can do, you can still make your brain injury. And then I would say one more thing. Never just try a brain injury case with just your MRI. Let's say you have a positive MRI with DTI, diffuse tensor imaging. Don't just do that and think you're going to win. That's just a picture. That doesn't mean anything. It just means that portion of the brain got impacted. But then you need to tell the jury, how is it impacted? Right. How does it change this person's life?
Yeah, because it's different when you tell the jury, this is what the injury is, and you basically are showing them an image that doesn't mean anything for them, to then telling them this is what the injury is and this is how it's affecting this person, which may resonate with them in a better way, and they can translate that into their own lives. And that starts with probably jury selection for you, right? Sure. And then you connect the dots all the way until opening.
Yeah, so you would correlate it. You have to correlate it, but you also have to do mechanism of injury, right? What do I mean? How did that brain get injured? Then you show that it's injured, And then you start talking about this injury correlates with these deficits, and then you bring examples.
Right. So don't tell them, show them.
You got to show. Show and tell. Like, yeah, we're going to be on a podcast here and they can hear it. Whoever's hearing it is great. But if I can show them what we're talking about, it's a lot different. Like, let's say you watch a soccer game or a football game. It's interesting to listen on the radio, but I would rather watch it on TV or live because you just see it. You get a better understanding of what happened.
Right.
So people prefer the show and tell as opposed to just tell.
Now, in terms of your work as a lawyer and as a trial lawyer, you started, at what age did you become a lawyer?
So at 24, I was already practicing law. And then that's really when it started, at 24 years old.
Okay, and then fast forward to your first result. You opened your firm at what age?
So initially I went to work for a defense firm.
Good training.
I wanted to do plaintiff's work. But sometimes it's hard to get a job. So I did defense work at a prestigious defense firm. I think now they're the largest in the state of Florida. So got a lot of experience there, and very thankful that I did it. I learned a lot. And then after that, I went to work with an attorney that does plaintiff's work, and we started trying cases. So at 28, I had my first multi-million-dollar verdict, which was nice.
Nice and very impressive. I mean, not many 28-year-old lawyers get a multi-million-dollar case result. And then you got this result working for this other lawyer?
Yes.
Did you try that case?
Yeah, so I picked the jury on that case. I did the closing on that case. We took witnesses. So we split the trial together. And it was both one of our first trials, which is weird, right? To get a big result like that on a nerve injury case. On a products liability nerve injury case. It wasn't an amputation or anything like that.
Was it a CRPS type of case?
No, it wasn't CRPS. It was just a nerve injury. The young boy put his hand, depending on which, because sometimes you get medical records. And in this case, they had 6 different versions of how the incident occurred. So that's one of the things we were dealing with. Did he put his hand on the lawnmower? Did he put it underneath the lawnmower? Underneath wouldn't make sense because they have that huge spinning blade. He wouldn't have fingers or his hand. So we said that he put his hand on this piece that didn't have a protective cover on it, and that was the whole case. They didn't use a 9-cent piece that could have made a difference on his nerve injury that he had on his hand.
And then what happened? He put his hand there, and the piece.
Yeah, so I'll give you some background. His mom was mowing the lawn on a riding lawnmower. And the riding, now this is a case from 2004, so we're testing my memory a little bit. She's riding the lawnmower. Little son, he's 8 years old, chasing her. He trips, and then to brace himself, there's the motor, not the motor that spins on the ground, there's the fan that spins everything. Now it's not sharp, there's no blades or anything, but it's still a moving fan. And he was coming to brace himself, and his hand, the right hand, went into the fan. And it messed up his nerves here. So that's what happened. Went to the hospital. Mom's freaking out. Fire rescue gets one version of how it happened. One nurse gets another version. There's 6 versions of how this happened. So we ended up suing the product maker. It was Kohler. So you notice there's Kohler. They make bathrooms. They make all types of engines. So they made that engine. We ended up suing them. They're the OEM, basically, the original equipment manufacturer. And then we sued the person that sold the riding lawnmower. And then we went to trial on that case. So it was a fun trial.
It's a products liability case, right?
Yes.
And those cases can be very expensive because they are expert intensive, and then sometimes you have to test, the products, buy them, and try to you have to hire engineers. It's expensive to go to trial on any case, right?
Definitely.
But I know that you are handling now cases that are very specific, and the cases that you handle, TBI cases, these products liability case, I don't know if you're still handling them as a niche, but also very expensive. And then wrongful death cases can be expensive too. And I know there was a path from being a young lawyer, you open your firm, right? Up until you got to a point where you said, okay, I'm going to specialize in this type of cases. And I would like to for you to tell our listeners about that path, because it's pretty fascinating.
So what happened was, I had worked for this firm. I then had a partner. We tried some cases together. That didn't work out. And then I opened my own firm with one associate. Okay. We started trying cases, and I grew to about 10 lawyers at one point. And then and we had gotten some 8-figure verdicts at that point. We were getting great results. And I got associated on a very large case. I can't really talk too much about it because we signed a confidentiality provision, but I'll give you some things that I can say. Okay. You know, and I don't want to violate the confidentiality because I don't want to get sued. Right. So we got this large case in 21. They associated me on the case, and we settled it. We're allowed to say that we settled it in excess of $100 million. I can't say the amount in excess, but it's a large amount in excess of $100 million for a single person. And after that case, I restructured the firm because I figured I just want to handle bigger cases, interesting cases, and cases where we can really make a difference for the clients, right? Stuff that from cases where women were sexually assaulted at a hospital when they were coming out of surgery, getting, looking for clots. They're doing sonograms looking for clots, and they're getting sexually assaulted. So I do some of those cases. A lot of the cases we handle are traumatic brain injury cases, but I'll tell your viewers I have 2 products liability cases going on. One of them is, I think, extremely interesting, and it's called, you ever heard of an AEB system in cars?
No, I have not. What?
This is for everybody to rethink about cases completely. Because what we're going to, all these cars are going to be self-driving eventually. And it's software. So you ever had your computer freeze? It happens sometimes, right? And you have to reboot. So you're having cars now that are automatic or working, and driving, and they can freeze just like a computer can. So what happened? Yeah. So what happened in my case is, my client's girlfriend gets stuck on the roadway. She got a flat tire. He's a passenger. He gets out. He rolls to the back, goes over to the back, opens the trunk, and then comes in to take out the tire. As he's coming in to take out the tire, another car is coming right behind him. And that car has an AEB system, which is automatic emergency braking system. And that automatic emergency braking system failed. And when it failed, it smashed right into our client. And it smushed in between the trunk and that car. They ended up flying him to the hospital, and they amputated both of his legs above the knees. So we're going, in that case, after Toyota and Lexus for their software failing because it should have picked him up. That's at least what they advertised to the world. We've got the best software, and it should have picked him up. So that's a product defect case. So now think about this moving forward. Sometimes you have cases where there's no coverage, right? But you have a horrific injury. Maybe the software didn't work, and you can turn that into a products case, because the software should be working. It shouldn't fail. And that's what we as the consumers rely on, whether you're the driver of the car or pedestrians. So those cases are out there for people to look into and get justice for their client.
Yeah, and that's what makes the difference between a great lawyer from an average one, right? Because a normal lawyer, what would have done?
They take the policy limits and move on and say, I can't help you anymore.
Right. But instead, you guys are going the extra. You're doing the extra leg work and going against the manufacturer. And of course, they have a big policy that will compensate this person for a life-changing situation.
Right. It's Toyota and Lexus. Right. They've got unlimited amount of money and a lot of insurance. So, and he needs it. Think about it. I mean, he comes to our office in a wheelchair, but he's got no legs. Like literally, it's above the knee. So it's a really sad situation. He had a very early 40s, young guy who his life has been really catastrophically changed. Right. That's a real catastrophic injury, right?
And how do you deal with the emotional weight of dealing with these clients whose life had changed completely? For me as a lawyer, sometimes it's hard to separate yourself to get outside of this like world of suffering and pain that your clients, and you kind of get sucked into it. What do you do? I'm sure that working out and doing the stuff on the side helps, right?
Yeah, but I think I'm like you. I get sucked into it, and it's really hard to step away. Mm-hmm. It is. The working out is the one time I do step away, but my family, they always tell me I'm talking about cases, right, just because it's in my mind, and you really want to help mm-hmm. some of these clients and what they're going through, and right, especially when you have a story like the one I just told you, mm-hmm. or we have a case against a trailer park where it went up and burned and a 4-year-old died. I mean, some of this stuff is really, really sad, mm-hmm. and it just sticks with you. Or I'll give you an example. Pretty much most plaintiffs' lawyers do auto accidents, right? You see some horrible things, and then even I recognize it when I'm walking on the sidewalk. If I'm going to cross the street, mm-hmm. if there's like a huge pole, I'm going to stand right next to the pole, because I've seen it where people are standing on the sidewalk, a car loses control and smashes into them. So I'm always like, I don't know if it's paranoia, right? Because just you live with it. It's hard, just like you're saying, it's hard to get out of that. Mm-hmm. You see so much bad, right? So it's hard to get out of that. Mm-hmm. It's hard to get that out of your mind. At least it is for me.
Right. And you probably have nightmares about your cases, right? From being in court and right. Yeah. When I'm about to try a case, I'm like thinking. I'd never stop, thinking.
Yeah, it's hard to sleep when you're. You got a trial coming up.
Taking a quick break, I am Federico Lathrop, your host, personal injury trial lawyer, and founder of Lathrop Law. I created Legal Latitudes for two types of people: the lawyer who wants to learn from the best in the business, and the regular person who deserves to understand the legal system before they ever need it. Because most of us only meet it in our worst days. If you've been hurt, call my office at 760-723-9612. You focus on healing, we'll do the fighting. If you like the show, leave us a rating and tell me who you want to hear from next. You can email us at office@lathroplawfirm.com or follow along at Fede Lawyer on Instagram and Fede the Lawyer on TikTok. Now, I think it's very interesting to go back a little bit into what you said about finding, different areas to compensate your clients when they suffer a catastrophic injury. And many times, potential clients that are looking for lawyers, they get to deal with lawyers that they know, that they work with for other reasons, right? Business, on corporate side, and they trust this lawyer because he's like the family lawyer, and they think that they're gonna do a good job for them in handling that case. And I've seen, we were discussing about a potential case in Florida, where the family decided to go, we don't know yet, but like that was on the cards, right? And I would like you to address that, because I think it's very informative for people who are looking for a lawyer, why it's important to get the right attorney for the case, and why it's important to do it quickly. And to close the question is, I want to finish with this. When someone suffers a very dramatic, catastrophic injury, the death of someone, the same case that you just described, they are mourning, they are grieving. They're not thinking about money, they're not thinking about legal stuff. They are thinking about, their spiritual stuff, right? Sure. So perhaps they made the decision, I'll talk to a lawyer later on. If it's a governmental case, that's going to have, a shorter period of time. Notice issue. But then on the preservation of evidence, the litigation front, they are making themselves a disservice, and the family also, like the kids that survived this parent that died, they may get a worse representation if these things don't play the way that they should. Sure. So I would like you to talk a little bit about that, because I think that's very important for people to know. Why it's important that they act fast and they act well? They go to the right lawyer?
Yeah, those are extremely important questions. So we'll do the first one is why do you have to act fast? Let's use a regular car crash case or a trucking case. First, a car crash case. Once the person gets into a car crash, and let's say someone unfortunately passes away, the insurance company for the at-fault driver, they're acting immediately. What are they trying to do? They're preserving evidence to protect their side, to protect their money. And they're not helping you at all, or the victim. Their goal is to save as much money as possible for themselves. So they're hiring experts. They're doing everything they need to do to preserve. Now, and they take statements. I've seen this happen. They take statements. If the statement is not to their benefit, that witness name just disappears. And suddenly you would have had someone who helped your case, but no longer, because the insurance company is not going to keep stuff that's not favorable to them. So acting right away and preserving the evidence, getting to the scene, seeing if there's, let's say it's a car crash, scuff marks. Are there any videos in the area that could help? Are there any witnesses? Putting an investigator out there, depending on what happened and where it happened. You need to hire the people, the accident reconstructionist, the human factors expert. I like to also hire a videographer. I don't want to be the one taking videos. I want to look and see stuff, and then we look at it afterwards. Taking a photographer as well. They're cheap. You get them out there, and especially if it's a wrongful death case or a serious injury case, you never know what you're going to find. And sometimes you find nothing, but you've preserved the evidence, and your expert may find something. So extremely important, and I know it's never the best time. There's after someone's injured or you lose a loved one to hire a lawyer, but you have to hire someone to preserve that evidence. Otherwise, the insurance company gets a huge advantage on you. So that would be the first thing. And then your second question is, yes, you have a family lawyer and they do your business and drafting, but those are two different things. It's sort of like cars are not the same, right? No, two cars are not the same. You can have a Lamborghini and Ferrari, or you can have a Kia. Nothing against the Kia, but you're talking about two different performing vehicles. Same thing with lawyers. You can get a lawyer. Everybody can get a law degree. You go to law school and you get your law degree. But there's high performers and there's low performers, or there's average. If you want an average result, go to an average lawyer. And then if you want someone who thinks outside the box and not just contained with the easy part of the case, go to your average lawyer.
Right.
So, but you really want to get someone who's a specialist, someone who focuses on that area. And I would say start off with, in Florida, we have board certification. So is the person board certified? Meaning, do they go to trial or do they just say they go to trial? Because if you go to trial and you do enough trials, you're going to want to get board certified. And it's not an easy process to do. You have to have a certain amount of trials. You then have to pass a test. It's sort of like board certification for a doctor. So they have national board certification and then state board certification. So that's number one. And then you want to look at, do they get results? Results matter because when I did defense work, we looked up the lawyer. We knew who was on the other side. Can we take advantage of that person? Because again, at the end of the day, it's all about money. You're saving money for the insurance company if you're the defense lawyer. And if the defense lawyer can look like a hero, they settled a case that's worth $10 million for $2 million, they look like heroes.
Right.
And what happens then? More business comes in. They continue to get business. And unfortunately, we see it far too often where people are not getting the full value or the full measure of justice.
Right.
And it's unfortunate because they don't know. They think every lawyer can do everything, and they can't. So for example, I like real estate, I buy real estate, but I hire real estate lawyers to do the closings because I have no clue. Could I possibly learn it? Yeah, but I think I may make a mistake because it's not what I do every day.
Right.
So someone who's looking for a lawyer, they should really look for board certification. Then they should look for, do they have the results? Then you can look for, are they the authority in the field? Do they speak on this subject? Do they teach on this subject? Those things are extremely important to give people, is this person really going to be able to help me and get me justice? So that's kind of what I would tell people.
And get full justice, not just, half justice is no justice at all. You heard that many times.
Yeah, the full measure of justice.
Right, right. Now, some people may think, how am I going to hire this attorney that gets multi-million-dollar verdicts and settlements, we don't have money. That's another myth that people don't know, that I think it's important to clarify, right?
Sure, absolutely, yeah. So, and I get that phone call. I don't have the money to pay you. This happens at least once a week. And so when we have these injury cases, clients need to know that I'd say 99.9% of lawyers work on a contingency in the United States. I don't know how it is in other countries. Some other countries you have to pay for case costs.
Yeah.
Here, there's no reason why you should be paying a lawyer anything up front. So the lawyer should be able to pay their own case costs, take the case on, pay for experts, pay for whatever it needs to be paid for, and work the case all the way to the end. So, and you pay a percentage. That's the way it works in every state.
Right.
Yeah.
I keep saying this over and over again, and this is what I tell my clients when they hire me, which is, of course, we're going to see how much coverage there is. That's going to put a limit, right? So if there is no coverage and there are no ways to find more coverage, that's going to cap what we get. Full disclosure right away. But if we can open this policy, we will, right? And then by the time we get an offer, the first question you need to ask me as a client is, how much am I getting after I pay you? How much I'm paying to the doctors? And if that number makes the client happy, I settle. If it doesn't, we keep going until the client is happy with the result, right? And as a professional, you give a recommendation on what you think the case is worth. But then the last resource is trial, and as a trial lawyer, you want to be ready from day one, right? So what are the first things you do when you get a wrongful death case? Let's say a family member, got involved in an auto accident, someone hit them driving a truck. Let's make that example. Or better, you had a case where, I think this is interesting, you had a case where a young lady or a young guy was drunk, right? Hit someone and killed that person. Right. And you were able to find good sources of coverage there that were not the usual sources, right? So what would be the steps that you take from the time that you get this wrongful death case to perhaps trial? Let's start with the beginning.
So as soon as we get that phone call, once we sign up the client, we want to go to the scene. I want to go to the scene. I want to figure out what experts I need and get them out there ASAP. So you have to have a team in place. Right. We have a team, and there's consulting experts, and there's experts we use at trial. A lot of times the experts you use at trial, they're not available that moment you need them, but we have consulting experts and people who can preserve the evidence. So especially if it's a crash case, I want to get the black box data, right? People think of black box and they think of only of planes, because that's where you hear black box data. The black box data said this. Well, they have them in cars. So for any clients, you'd want to get that black box data from both vehicles. If there's more than two, you want to get more. You spend the money and you find out, because the black box data will tell you how fast they were going, usually about 5 seconds before the crash. How fast they were going, were they pushing the throttle, were they pushing the brake, what was going on during those 5 seconds. Now you can take the black box data, and sometimes, just so you know, some cars have video in the cars and they record as well. So there's a video card. So you got to look into that and preserve that evidence. You want to build your evidence at that time. Don't wait and take your time. If you're taking on one of these cases, it's extremely important that you do this stuff early, so it doesn't disappear. So immediately speak with the client, and then I tell the client also, so now the client's got homework. We'll do the legal side of it. I need to know who was it that passed away, right? I want to see videos. I want as many videos you can get me as possible, as many pictures you can get me as possible. People who knew the person that passed away, people who had contact with him, people who worked with him. So while one team in my office is dealing with the liability, that's how the crash happened, the other team is dealing with, we're going to preserve what we need for the human side of it. What happened to this person? What happened to this family? And we can put that story together to start understanding the story. So it helps if you have on your team one person on the team to work on liability and one person solely just to focus on damages, because it's hard to split your time in both. You really have to unless it's such a clear-cut liability case, then you can just focus on damages. But immediately, right away, preserve evidence, and then worry about, obviously we want to get coverage and find out the coverage, and then if the insurance company makes the mistake and they don't pay the policy limits in a timely manner, then you have that open policy. And they make mistakes all the time, and then they cry, right? They say, oh, he set us up. You mean Federico or Sagi, two small lawyers, right, against your multi-billion-dollar company where you have thousands of lawyers on your side? We set you up? I don't think so. Right. We give you opportunities to pay.
To do the right thing.
And if you don't do the right thing, you can't come cry about it later on. So that's always an issue.
So let's say they do the right thing and they offer policy limits, and you find out, policy limits are not enough, right? You find other ways to get paid. And there are other ways, most of the times. So why don't you tell our listeners about situations like that case that you told me off camera of this young driver who killed someone else, I think, or injured badly, this other person. You said we went against the bar that served them alcohol.
Yes.
Right?
Mm-hmm. So we had a case, and it's actually really interesting. It's sad, right? A 6-year-old died in this crash. It was a left turn case. Our client was making a left, and the driver that was going straight was going 110 miles an hour in a 35-mile-an-hour zone. And you couldn't tell from far away how fast he was going because he was, flying. And he was drunk, and he had drank at a couple of different places, from a bar to home, and he was underage. So here you have a real big problem for the bar, and you have a real big problem for the homeowners, because homeowners coverage would pick up, the bar's coverage would pick up, and so you're able to get from everybody. The kid didn't have any money. He had a $10,000 policy. That's not going to make or break anything. But the policy at the bar was significant, and then the homeowners, they also had insurance coverage. Right. So we were able to go after those different coverages. So never just think if you've got a significant case, you want to try to really just sit down and think, where can we get our money from? Just like the automatic emergency braking system case. Right. Or we had a case where the individual was sitting on the bus stop, and a driver is driving. Driver loses control and smashes into him and kills him. What do? The driver only has $100,000. So we took that driver, we filed suit. I go, something just doesn't add up. This is a doctor, and he's a radiologist. And so once you put it in suit, you found out that... Umbrella. Well, not the umbrella. We didn't get the umbrella. But what he was doing and caused the crash was he was looking at his phone and reading scans while he was driving. Yeah. And so we were able to tie in the employer into it, and the case settled. But it does require digging, and it doesn't, some people want what's called a low-hanging fruit, the easy money. Right. It would be nice to get the easy money, but it seems like you have to, and it's never easy, but you still have to do the work, to uncover every rock to try to get the client's money. And then some other cases that you start seeing this in trucking company cases, right? Whether it's Amazon, FedEx, DHL, all these companies, what they do is they set up independent contractors to drive their trucks. So while it says Amazon on it or it says FedEx on it, if you look closely at the trucks, there's always a company name there, and it's not FedEx. They're driven by another company, and that company, we'll use FedEx for example, or Amazon, it applies to the same. They only work for FedEx, or they only work for Amazon. And Amazon and FedEx have a very unique program where they're trying to avoid liability. Right. It doesn't work. I mean, it may work if the lawyer is not paying attention and not doing what they're supposed to do. So people should be on the lookout for that stuff. That's another avenue to get more than just the policy limits they tell you. Right. To go after the big company as well.
Well, we have now the Montgomery decision, right, on the big truck.
Oh, the broker case. Yeah. Yes, that's a very good Supreme Court case that just came out. That the trucking industry through the brokers were trying to limit their liability. Imagine they get a free pass. They can pick negligent companies who don't meet the safety ratings under the Federal Motor Carrier Safety Administration and just get away with it.
Right.
And so the Supreme Court said that just doesn't make any sense. Not in America. Maybe in some other country, but not in America. You don't get away with picking a crappy company to get on the road and haul from one place to another, and then if they cause or maim someone or kill someone, they get away with it. It doesn't work that way. So thankfully, they came out with a good decision.
Right. It's the same that the gig company tries to do, right? They try to say, well, we're like a tech company. We just provide the platform. Our drivers, sign up and they drive their own cars. We're not liable for whatever they do. But ultimately what they do is they get all of the benefits of the activity, but not, the costs that activity comes with, which is safety and not causing people, injuries and change people's lives.
Yeah, and speaking of that, what I would look at if you have one of these and it's what we call a catastrophic case, if you have someone who's on the app, whether it's Uber, Lyft, or whatever other kind of company there, I know in some states they have different companies, but imagine someone's driving, right, and you're holding your steering wheel and you're driving and you get pinged. And what happens when you get pinged? You're doing this. And it literally takes 1 second when you're getting pinged and you're looking at that phone for you to drive and run someone over. Right. So that app is distracting. So if you've got a catastrophic case, I'm not talking about a case where you work it up for a fusion or something like that. Someone who's really hurt, and we've got this case going on right now, where they're really hurt, you've got a products liability case against the application, right? Because the application is inherently dangerous. It distracts drivers all the time, and drivers are causing crashes because there's studies that show even seconds after you get a text message, you're distracted. The brain is distracted. So here, you're not just getting a ping for your next ride, you're getting constant pings, and that can be distracting. And that, that's in my case, that caused my client, she's a quadriplegic. So we got that case going on right now.
Oh, wow. Yeah. That's a creative way of getting more money out of that. And then attacking them directly without subjecting anyone to like any type of agreement that they have. In this case, someone got hit by the driver, right? But if it was the driver, the one who gets injured, you would be subjected to this arbitration clause that Uber likes to, Sure. And I think by that theory, you can overcome the arbitration clause because it's like besides what's agreed, right? Which is driving for Uber. So I like that. I like a lot that approach.
Yeah, we're always trying to change our approach or figure out what can we do differently to get this person compensation and justice for what happened.
Right. And what's interesting is that the more you dig into, you get into litigation, you start getting, corporate documents and things that happen behind scenes, you start realizing that they know this thing is going to distract drivers and they prefer to keep it rather than making it safer. And that's what really changes the game by the end of the day, right?
Right. If you get that document, that's a game changer because now they have knowledge, like you said, and they still don't care. They stick their head in the sand and just continue on with business like it's normal. Right. And then who's affected? People like you and I and our clients and people walking in the streets or in their cars. And their life gets transformed for no reason because one of these big rideshare companies puts their head in the sand and just don't care.
Right. It's the same as the meta cases. They know that these apps are causing young, kids to become addicted to their phones, and they keep them rolling like that.
Yeah, it kind of reminds me because they just recently had some of the verdicts, one in California, I think. It reminds me of the nicotine. They knew they were, making this addictive substance. Right. And it caused people to be addicted, and now you become a consumer for life. Same thing here with the social media. You're a consumer for life, and it's addicting, and and the damages are there.
And all these cases, for people who don't know the ins and outs or that are not involved in the weeds of what these cases are about, they say, well, if you're smoking, it's your decision. If you're looking at your phone, it's your decision. The point there that makes a whole difference is that these companies know things that you as a consumer don't know. and they have known this for so long.
And they target the unconscious mind.
Right.
They know exactly what they're doing. So, for example, what do I mean by targeting the unconscious mind? You walk into a supermarket. These supermarkets study what works and what doesn't work, what shelves to put certain products on, because they know where your eyes will gravitate to. Same thing like a casino. They use certain colors for a reason. Same thing with Meta, and they study. They know how to get into that unconscious mind where you think you have control. You don't have control. I'll give you an example. You're driving and you go from point A to B, wherever it is, you're going from home to work. I guarantee every single person, and it's a hard statement to make, but is not thinking about, I got to push the brake, I got to push the gas, I got to push the brake, I got to push the gas, I got to turn my wheel. Nobody's thinking of it. They're in automatic mode because your unconscious is getting you there.
Yeah.
So when Meta or some of these other companies can go into a person's unconscious, you don't have control anymore. And that's what they're successful in doing. They're brilliant from doing that, you know, and then turn that over to, if you as a lawyer can get into people's unconscious mind, now you become like the Meta, right? You become, if you can do that with the jury, that becomes great too. It's hard to do.
It's hard.
And it takes a lot of practice. There's NLP, you've heard of NLP? Neuro-linguistic programming.
Yeah.
It's a whole field in and of its own, and it's really unique, and it's that's why I like studying the brain. It's fascinating.
Right.
Yeah.
That's awesome. Well, we're running a little bit out of time, and I want to play a game with you. I know that you present on the defense and insurance moves, you know, in cases. So what I'm gonna do, I'm going to make a statement or tell you what the move is, and then you're gonna tell me what the truth behind that move is, and how you beat it. Okay?
Yeah, let's do it.
So the first move is insurance lawyer serves your client with a proposal for settlement. It's a lowball offer, and say, if you don't beat us at trial, you're gonna have to pay our fees.
So that's a true statement, right? Yeah, every state is different on the percentages, but if the insurance company serves that proposal and you don't get within a range that's required, then you may have to pay, you the client would have to pay the other side's attorney's fees. So how do we beat that? I mean, obviously you want to win the case. We never want to lose a case. And I'd always say it always comes to case selection. Be careful about what you're taking, because as a lawyer, it's your time, right? And if you put your time and energy into the wrong case, that could affect you. And what I tell this to lawyers when I teach a class, if there's a scratch on a car, that's not the case you need to be taking.
Right.
Because you're going to be spinning your wheels, and you know who's going to be super happy about that? Not the insurance company. But there's a defense lawyer who's going to have a huge smile on their face because they're going to look like a superstar. They're going to go in and win that rear end collision case because you look at that car and there's just not a scratch on it. And how can anyone get hurt? Yet they're working the case up for injections, infusions, and you're wasting everyone's time. So I would say, if you're good at case selection and you believe in the value of your case, that proposal for settlement is not going to mean anything.
Right. And what lawyers usually do on the defense side is tell you this so that your client feels pressure and they settle for this low ball
They try
offer.
to scare the clients, absolutely.
It's like fear inside.
But you can reverse it and do it to them too.
Right.
And you have to be careful when you're doing a proposal, because the insurance companies will tell you, well, you did the proposal, let's say for 400. You did it for 400. Now you come to mediation. It's a year later. They're like, you got to start at 400. Right. So I write a letter. When you're doing this proposal for settlement, if you're intent on trying the case, if they don't take it, you put them in writing and you let them know, hey, here's your one opportunity. It's not going to happen again. When we go to mediation, we're not going to be at 400. Let your client know. Let the adjuster know. Let your team know. Let the committee know. This is your opportunity. And sometimes they take it, and then a lot of times they still tell me, hey, we want you to be at 400, for example. Not going to happen.
Right. The empty chair, when they blame a no-show or non-party, favor defendant.
Yes. So yeah, that happens all the time. Anything to avoid liability, right?
Right.
So in Florida, they call it FABRE. Do they call that here also?
No, but I know in Florida that's the name.
Yeah, it's FABRE, FABRE. It's a case called FABRE versus Marin, where the insurance company or the defense lawyers can blame that empty chair. So that is true. They do that. How to avoid that? There's a great book called Rules of the Road. Have you read the book?
Yeah, Rick Friedman.
Yeah. It's a book you must read.
Yeah.
And that really helps frame cases. And you really got to frame the case. What we like to do on our cases is we focus group the cases, and then we'll mock try the cases to make sure that our theories of liability resonate with the jury and they make sense. Because sometimes, or I'll tell you for me, I think the argument we have is great, but the focus group doesn't think it's great. So I have to change my approach because what I think is great is not what they think is great, and I need it to resonate with people, not just me. While I think I understand how people think, I still always test it because it's better to test, you get results. The more testing you can do, the better. And you want people in a situation where they're going to be in like in a trial, where they can deliberate. So just asking people individually to fill out survey forms, that gives you information, but you don't know the dynamic, how they're going to be when they're together in a room. And obviously the person who's more commanding is going to take control. But how are they going to be when they argue it together? That's why you want to find the information.
Yeah, a lot of work goes into going to trial that like happens.
Tremendous amount of work that you don't really see. And then everyone thinks, oh, that was easy. Of course you won that with that frame, with that, you know, but it took a long time to get there.
Right. Move to bifurcate. What's your position on that? Do you like to split liability from damages? And let's explain a little bit what bifurcation means.
Sure. So bifurcation is when you have, let's say, a crash case, the defense wants to potentially, or the plaintiff, wants to just try liability as opposed to trying damages. And if you win on liability, they potentially will pay you on damages. So it depends. So here's one rule I'll tell you. If you have a TBI, which is a traumatic brain injury case, what I would do is there's case law that says you can't bifurcate those cases because my client, for example, has a TBI, doesn't have good memory. And I'm not able to explain that. I need a doctor to come in and explain why he can't remember things. And I can't do that if I don't have my damages section. So then it doesn't make sense to bifurcate. But sometimes it can make sense, although I would say not to bifurcate because then the insurance company has no pressure. And that means you're definitely going to trial. And sometimes clients don't want to go to trial. So in our favor, I don't think it's the best thing unless you're trying to save money on costs and you just want to see if you can win. If it's a very difficult case, you try the liability. If you win, great. Now you can pour the money into the case.
Right.
So maybe on extremely difficult cases you do it, but on a good case you don't want to bifurcate because the pressure goes down from the insurance company.
Right. I saw that Nick Rowley had a couple of these coffee cases, and I think he lost one before the big Starbucks case. Right. And that case was not bifurcated, and then the Starbucks case got bifurcated. He won on liability, and then he tried the damages and got like a 50 million or something. I don't know the exact number. And then he started bifurcating these cases. So it's probably a case to case, right?
Yeah, definitely case by case, and especially when you're talking about a case that sounds like the McDonald's case, right?
You want to know if you win.
Yeah, you might as well just bifurcate that case. I agree. That's why it's case by case. You're right.
Right. Fight the billed versus paid on medical bills.
So in Florida, we just recently had tort reform in 2023, where the insurance companies and their lobbies, their lobbyists, were able to get the Florida legislature to pass a bill that is very beneficial for the insurance companies and for defendants. And what it is in Florida, and I think this is coming across the country now, they want to bring in billing experts. Do you really want your case to be about medical bills or to be about the human being? If you want a case about medical bills, you play in their sandbox.
Right.
If you want the case to be about the human being that got injured, you play in this sandbox. So that's what I would say. I don't want a case to be about medical bills. They may want it that way because you confuse the jury. If the jury's confused, you as the plaintiff's lawyer, we lose. If the jury's not confused and they understand, then we win. So I prefer not to address all those medical bill issues and focus more on the human being that got impacted.
Okay, great.
What about you?
So it depends if the medical bills are, you know, huge. I of course make my client decide with me if they want to waive it, because there is a risk involved in waiving the medical bills. But yeah, the whole point of the case needs to be the human impacted. Now, whether you waive or you keep the bills in, you need to be able to tell the jury that this is not about a ratio between the bills and what my client suffered. I like to waive the medical bills when they are anchoring your non-economic damages. Yeah, a low anchor. If you have like, I don't know, 20,000, 50,000, and then you know that your client's life changed, you know, from the time of the injury, and it's going to change in the future, I might as well just waive the full 50,000 and go and tell the human story.
We're on the same page 100%. Now, that case I settled for in excess of 100 million. Mm-hmm. We had over 10 million in past medical bills and 38 million in future medical bills. I wasn't waiving those bills. Right. You're talking about almost 50 million, so I wasn't going to waive that. Yeah. That's a different story, right? Yeah. But we're on the same page.
Awesome. Sagi, we're getting out of time here. I have so many things to cover with you. I think we need to come to a wrap up. But what are things that like you have done in your practice that have, you know, changed the person you are today? Cases that still follow you home, that made you the person you are, that inspire you, anything like that?
I think it's changing people's lives for the better. And I recently got, I want to say about 3 months ago, I got the nicest phone call from a client I represented over 20 years ago. Mm-hmm. How the money they got from 20 years ago, right? I've been doing this now almost 27 years. The money they got 20 years ago still is helping them in life. And that makes you feel good, right? You've done something good for another human being. That makes you feel good. Or the case that we had against the hospital system, it's confidential, so I can't say, where they now implement the 2 adult rule. Mm-hmm. So another, you know, if you have a male on female, you're not having someone get sexually assaulted. So women are protected, men are protected. When they're in that role or in that setting, you're in a room and there's a male, and I'm not saying all males, again, there's always a bad few apples in every group, right? And so this is to prevent those bad apples. So mm-hmm. instead of having just a man with a female in the room, a female patient, now you have a male with another female in the room, and then the female patient.
I see.
So the female's protected.
Mm-hmm.
And it can work vice versa. It could be a male patient too. But you want to have that. So that's something that we did, I think, that was really positive and changing, because part of the settlement required that to happen, not just money. And that was really thanks to our client, not really. I mean, we wanted it, but the client was insistent on it, so it doesn't happen to another person. So that really makes you feel good that you're doing something good for society. You're not just, we're not just doing it for money. We really want to make a difference.
The non-monetary clauses on settlement agreements, right?
Yeah. So again, and because it does make a difference. Mm-hmm. Yeah.
Also, so changing society for the better. And that's something that you see in this country, that if it wasn't for us plaintiff lawyers, corporations and people in general would be out there rogue doing everything they want, and safety would not be part of society. And in part, you know, when there is accountability, safety, it's something that people consider when they are doing business, and we are the ones who are policing so that happens. Right?
Exactly. We hold them accountable, just like you said. Mm-hmm. If we're not there, who's going to hold them accountable? Mm-hmm. Government's not going to do it, so we have to do it, and we get that power through the laws. Mm-hmm. And unfortunately, you see it in some countries where the lawyers don't have the power that we have here to make a difference. Right. And they get impacted. That's why there's no place like America.
Mm-hmm. Yeah, that's right. All right, Sagi. So for people listening, where can they find you? What are your, different platforms? Are you on Instagram?
So I'm on Instagram, Facebook, and LinkedIn. If you look up my name, Sagi Shaked or Shaked Law Firm, if anybody has any questions, feel free to reach out to me. I like helping lawyers. I like helping people. And we do it all the time. So I'm still practicing law. I still love what I'm doing, and I love helping people.
Awesome. Thank you, Sagi.